We're all familiar with Donald Trump's Second Amendment executive order and the fact that he has asked the government, specifically the United States Department of Justice and Attorney General Pam Bondi, to give him a report laying out the new posture, the marching orders, if you will, of the Department of Justice in terms of it protecting and advancing and restoring our Second Amendment right to keep and bear arms. If I could dictate the main points in that report to President Trump, here are the 9 buckets of items that I would like to see in such a report to President Trump. Let's talk about it now. Hey folks, I'm Mark Smith, host of the 4-Box Diner, proud American gun owner, constitutional attorney, member of the United States Supreme Court Bar, and I'm proud to say the top voice of the Second Amendment in America, thanks to the 2025 Gundies Awards. Thank you all for your support. It was a great honor, and I hope to continue to do good work and bring you great information this year, 2025. All right, folks, so you're all aware of the Second Amendment executive order brought about by President Trump. I think this is great news for the Second Amendment for many reasons, and we've talked about it in prior videos. So what does this executive order ask for, and what should the answer be? Specifically, as you know, it asks for the Attorney General of the United States, Pam Bondi, and others in government to put forth really a report at the end of 30 days about what should the Trump administration be doing to preserve, to advance, to restore our Second Amendment rights to keep and bear arms in all respects, including, but not limited to, fixing all that nonsense, anti-gun nonsense promulgated by Joe Biden's administration and his Office of Gun Violence Policy, or whatever that thing was in the White House. So with that said, I'd like to give you, this is the Mark Smith approach, the 9 buckets of items that I would like to see in that report, or I would like to see the Department of Justice do moving forward to restore and or protect our Second Amendment rights. And I'm going to try to go in sort of order of preference or priority, and you can tell me if you think I got any of this wrong or I missed some items. Obviously, there's an infinite number of things that we could do to improve our Second Amendment rights across this great country. I'm not going to try to touch on all of those, just the big ones that I think that when you're setting policy for the President of the United States, you should be advancing, in my opinion. So number 1, let's start off with the most basic fundamental thing. What is the most important thing that we can be doing in the Second Amendment community, and what can the Department of Justice be doing to protect the Second Amendment community and our right to keep and bear arms? Well, I think the most important thing is, of course, to get more favorable Supreme Court rulings in favor of the Second Amendment, embracing the Heller-Bruen methodology and knocking out gun control laws across this great country. That should be the priority. And the reason why I say Supreme Court rulings in favor of the Second Amendment should be the priority under this executive order, if you just think about it for a moment, what is the one thing that's kind of permanent versus ephemeral or temporary? And that is, if you get a Supreme Court ruling in favor of the Second Amendment, that is basically permanent, unless, of course, we lose control of the Supreme Court in all respects. And then, of course, who knows where we'll be as a country. But that doesn't appear to be the case any time in the near future. In stark contrast, ATF regulations can be promulgated, they can be taken down, they can be promulgated. So I mention that because, and also congressional statutes to some degree. Even congressional statutes can be permanent or temporary and everything else. But if you think about it, whatever Joe Biden did in the last few years with ATF, Donald Trump can basically unwind. And that's a good thing, of course. But then if you get, Josh Shapiro, the governor of Pennsylvania, to be the next president of the United States in 4 years, I don't think that's going to happen, but let's say it did, he could bring back all the Joe Biden ATF regulations and rulings. So again, the one thing that is to the extent it's permanent, anything can be permanent in the human experience, a Supreme Court ruling on the Constitution, the supreme law of the land, is the best thing we can shoot for. Obviously, other things are important too, but there's no more important thing, in my opinion, than favorable second rulings by the U.S. Supreme Court that will be with us for decades and decades and decades, as opposed to changes with the ATF that can get swapped out every 4 years with a change of administration. Okay, so with that context, with that understanding in mind, this is how I prioritize the Mark Smith 9 buckets of things that I think the Department of Justice should be doing pursuant to that new Trump executive order. Number 1, let us look at cases right now where a federal statute has been struck down on Second Amendment grounds by a United States Court of Appeals. And in the normal course of American law, if a court of appeals, a federal court of appeals, knocks out a federal statute on constitutional grounds, almost always the presidential administration, through the Solicitor General's office, which is part of the Department of Justice, would seek cert to the U.S. Supreme Court to say, we have one court of appeals that's knocked out this federal statute as unconstitutional, and we want you to grant cert, Supreme Court, and hear the case, and then we want you to declare that federal statute to be constitutional and uphold the federal statute. That would be the normal course if you were answering this question on, let's say, a law school exam. But at the Four Boxes Diner, we elevate your game above mere law school answers to sophisticated legal strategies. So what should happen here, and what are the cases this should apply to? So one of the two cases right now that a court of appeals has declared a federal statute unconstitutional, and it's possible to seek cert on them. And in the normal course, they would be sought cert by the federal government, the Department of Justice. Well, that is, of course, the Bryan Range versus Merrick Garland case out of the U.S. Court of Appeals for the Third Circuit, which is a nonviolent felon case. It says someone who is not violent, but who has committed a quote-unquote felony as defined by the federal statute, cannot be disarmed for life because he or she is not dangerous. And 18 U.S.C. 922 G1, the federal felon in possession statute, is unconstitutional to the extent it seeks to disarm a nonviolent criminal for life. They cannot be disarmed for life because they committed a non-violent felony, because there's no evidence that they're violently dangerous in any respect, which is an example of how the Rahimi case actually helps us in this context. So the Range case right now has been decided by the Third Circuit Court of Appeals, as has the Reese case. The Reese case, which if you've been following the Four Boxes Diner for the last 18 months, I've been saying for over a year now that one of the next Supreme Court cases, in my opinion, will be that Reese case. The Reese case out of the United States Court of Appeals for the Fifth Circuit down there in Mississippi, Louisiana, and Texas. Fifth Circuit's usually pretty good on the Second Amendment, among other issues. Well, the Fifth Circuit in the Reese case said that the federal law that provides that 18, 19, and 20-year-old young adults do not have full-blown Second Amendment rights because they cannot buy handguns from gun dealers. They cannot buy handguns at the age of 18, 19, or 20 from an FFL, which is kind of stupid if you think about it, because they're allowed to buy guns out of the back of a buddy's trunk in a dark alley somewhere. That's perfectly fine under federal law, but they can't go to a gun store and buy a gun, specifically a handgun. So the Fifth Circuit Court of Appeals in the Reese case said that federal law that prevents 18, 19, and 20-year-olds from being able to buy handguns from FFLs is unconstitutional under the Second Amendment. So again, in the normal course, the U.S. Department of Justice, on behalf of the federal law, would seek cert to the U.S. Supreme Court. They would seek cert in the Range case dealing with nonviolent felons, and the Reese case dealing with 18, 19, and 20-year-old Second Amendment rights. And they would argue after cert was granted that the federal law should be upheld. Now, because you're at the Four Boxes Diner, I'm going to tell you what the Department of Justice should really do here. Instead of seeking cert on those two cases and arguing in favor of them, what they should do is this. They should do what the Barack Obama administration did in the Windsor case. Specifically, what they should do is they should seek cert in the Reese case out of the Fifth Circuit and the Range case out of the Third Circuit. They should seek cert, and they should tell the U.S. Supreme Court that we, the Department of Justice, are going to continue to enforce these laws. I mean, if you're a nonviolent felon and we catch you with a gun, we're going to put you in prison. If you're an 18, 19, and 20-year-old and you try to buy a gun from an FFL, we're going to put you in prison, and so on. So they're going to continue to enforce the laws, which you need to be able to say, because if you say that, it means that you're still going to have an Article 3 case in controversy. You're still going to have a live case, which you need to have to get into federal court and get into the Supreme Court. So the federal government will say that we're going to continue to enforce these laws under Reese and under Range. However, when cert is granted and the Supreme Court hears on the merits the Reese case and the Range case, the Department of Justice will flip sides on the merits and say, we're going to continue to enforce this law. That's true. But we think, Supreme Court, that you ought to strike down and affirm the Fifth Circuit in Reese and the Third Circuit in Range, and affirm the fact that these federal laws do indeed violate the Second Amendment. You see how that works? They will argue, they will seek cert, they will get cert granted, they will argue there's still a case in controversy because they're going to continue to enforce these federal laws in the other parts of the country where they're still enforceable, and then they're going to flip sides and argue in favor of the Second Amendment against these federal gun control laws in the case of Reese and Range, which is before the U.S. Supreme Court. It should be. That's how I would handle those cases, and those are both very winnable cases before the U.S. Supreme Court, and it would be great to get more favorable Second Amendment rulings out there on the books. And this was the quickest, easiest way for Pam Bondi's Department of Justice to do that. Now, the second bucket is lower court cases where there are Second Amendment challenges to federal statutes in play. Now, it was going to require a little bit of nuance. There's some buckets they should seek to uphold the law. I'll tell you why in a second. And other buckets or other arguments where they should try to concede error. So the way I would do it here is this. I think there's at least 3 areas of federal statutory law that clearly violate the Second Amendment, and the Department of Justice should basically acknowledge that in the lower court cases. Obviously, we've already mentioned 2 obvious cases already. That's the 18, 19, and 20-year-old bans on young adults being able to buy handguns from FFLs. That's a no-brainer. You have the nonviolent felons rulings out of Range. That's another no-brainer. But I would also add the currently pending challenges, and this is important because it speaks to the issue of sensitive places or government-mandated gun-free zones. I think the Department of Justice could easily switch its position and argue that indeed a gun ban or the gun ban on carrying handguns into post offices is unconstitutional under the Second Amendment. There is no basis for that in law or history. They're not secured locations. Everyone is totally vulnerable in a post office. In fact, there used to be sort of a morbid joke out there about people going postal. So, there are instances of people committing violent crimes in post offices. And I think this would be an appropriate way to do so, to declare that post offices are no longer sensitive places, and that to the extent there's legal challenges out there involving this, the Department of Justice should take the side of the Second Amendment against the gun bans on post office. Now, with that said, Now, I know you may get mad at me, but I've shot videos about this. This is very important. With respect to this very dangerous issue of arguing today in 2025, not forever, but today in 2025, we cannot be arguing that machine guns are protected arms under the Second Amendment today. We cannot afford a Supreme Court ruling that says that machine guns are not protected arms, because not only will that mess us up for machine guns forever, which will be terrible, it will also have a negative ripple effect potentially on allowing us to protect AR-15 semi-automatic rifles and magazines that hold more than 10 rounds, as well as potentially suppressors. So a lot of terrible ripple effects. So what should the department do on these machine gun cases, like that case in front of Judge Carlton Reeves out there in the Southern District of Mississippi, or whatever that is? And the answer is, the Department of Justice, whenever they're dealing with a nonviolent felon situation, a nonviolent malum prohibitum situation with a machine gun, they should seek to resolve those cases and avoid litigating those cases. They should either drop the appeal, for example, out of that Judge Carlton Reeves ruling, and try to avoid creating any bad precedent for the Second Amendment dealing with machine guns. But to the extent they're going to argue the machine guns are not protected arms, the way they should at least do it is to embrace the Heller methodology. They should argue analytically correctly that Heller is still the right law to apply on arms ban cases. The in common use test remains the law of the land. They should embrace all that, but then they should argue that as applies to machine guns are not in common use because there's not enough of them. There's only 176,000, and that is what they should argue today. Now, again, This is not about, you don't come to this channel for my personal goals, my wish list, what I want from Santa. That doesn't do you any good. It doesn't do the Second Amendment any good to, talk about things that are just not doable. And like as I point out before, we cannot win machine guns right now. We cannot fight that fight. It will be a losing fight and a terrible, terrible loss. Don't touch that with a 10-foot pole. There are people out there trying to bait us into biting the forbidden fruit. Don't do it. It's stupid, terrible mistake. Don't even think about it. Okay, so that's what I would do with those lower court cases dealing with federal statutes that are in play. Now, the third thing I would say is it's very important that the Department of Justice start to embrace the proper methodology. If you look at what some of the arguments made by Elizabeth Proligar and the Department of Justice, they were really trying to gut the Heller methodology and the Bruen methodology. They were trying to argue, for example, in the post office cases, we saw Joe Biden's briefs argued literally that Bruen does not apply to sensitive places, that methodology doesn't apply to sensitive places. That is clearly wrong, and the Department of Justice should argue that the Heller-Bruen methodology of text first and then historical analog second should apply to all Second Amendment cases as an example. And they should say arms ban cases should be governed by Heller and so on and so on. But they should be embracing the proper methodology and jurisprudence of the Second Amendment and not trying to gut it, which is what Joe Biden was trying to do with cutesy language in their legal briefs. So the fourth bucket, I would say, is when the Department of Justice has an opportunity to weigh in on a state case. Now, the Department of Justice has no real direct legal authority in a state lawsuit. For example, Illinois' ban on AR-15s, New York's messing around with sensitive places, whatever you want to say here, the Department of Justice technically doesn't have legal authority in these cases because these involve state laws, and these are Second Amendment challenges to state laws. With that said, nothing prevents the Department of Justice from actively supporting the Second Amendment community, especially before the Supreme Court, by filing amicus briefs arguing that the state anti-gun law should be struck down. For example, they could file an amicus brief in the Snope versus Brown case dealing with AR-15s out of Maryland or the Ocean State Tactical case out of Rhode Island. They should start to seek to file amicus briefs in support of the Second Amendment against these state laws in the normal course, and they should start doing that all the time. Number 5, dealing with the fifth bucket is ATF issues. I don't want to belabor the point. The most basic thing that should occur is every single thing that Joe Biden did with respect to ATF should be reversed immediately. No debate. Whatever he did, just change course, go back to the original Trump policies of the first term, and then you can try to improve from there and and there's ways to improve. We don't need to belabor the point here. You know what I'm talking about. But at the minimum, get rid of all the Joe Biden policies and then try to noodle and improve, different interpretations of the ATF and whatnot going from there. Now, the sixth bucket is what I call strategic pardons. I'm not going to name any names here, but there's certainly some people out there that have been convicted of malum prohibitum, victimless crimes under gun control laws who've had no criminal record whatsoever, no violence, no nothing, and yet they get to go to prison because they violate some malum prohibitum, non-evil, non-moral, nothing, right? Just kind of a victimless crime created by the legislature, and there are people there in prison who should be pardoned, strategically pardoned. I think that would be very good for the Second Amendment community. I think that would send the right message that these federal gun control laws are not about harassing those that pose no danger to society. The seventh bucket is, I would argue that the Office of Civil Rights under hopefully Harmeet Dillon, if she's confirmed when she's at her hearing, should start to look at licensing divisions like the NYPD, any of these law enforcement agencies that are engaged in the issuance of concealed carry weapons permits, CCWs. They definitely should be looked at if it turns out they're taking too many months or too much money to get these licenses. It violates the Bruen precedent that says unequivocally you have a fundamental right to carry guns outside the home for the purposes of self-defense. That's what the right to bear means. The right to keep means the right to possess. The right to bear means the right to carry guns in public. And to the extent you're denying people CCW licenses for many, many months on end, that seems to be a clear violation of American civil rights. A perfect target, if you will, for the Department of Justice's Office of Civil Rights, and they should laser focus on this. And the eighth bucket is actually technically more of a White House observation, which I'm going to just throw out there, which I have repeatedly said I think, a gun czar. You don't need an office. You just need one person that's very good, maybe a talented lawyer, whatever, that is the gun czar, Second Amendment czar, and that person's only job every morning is to wake up and look around the deep state. What is the Department of Interior doing with respect to anti-hunting regulations? What is the, what is NIH and what is CDC doing in terms of promulgating anti-gun statistics and anti-gun studies? Whatever it is, you want someone every morning waking up, looking around the country, identifying things that the deep state is doing to undercut our Second Amendment rights, advance the interest of government power with the ATF or whatever it is, and try to nip it in the bud from the White House. I would call that, just like we have Tom Homan is the immigration czar. He didn't need to be confirmed by the U.S. Senate. He works for the White House. He is the immigration czar. Have a Second Amendment gun czar that's very strong, that does kind of what Tom Homan does, except let that person do it to advance the Second Amendment. The ninth and final bucket is dealing with FOIA requests. You know there's a federal law called the Freedom of Information Act. Now, the Freedom of Information Act allows you and I and all sorts of people to submit requests for information from the federal government for emails, documents, and the like. And the game that gets played here historically is that for example, I'll send in a letter to the Freedom of Information law and say, hey, I want every email that was sent by Joe Biden's Office of Gun Violence Prevention, whatever they call that office that Kamala ran. I want every email sent out of that office to any outside third party, including the anti-gun groups. Well, historically, that would take me like 4 years or something to get emails back because there'll be these privileges and all this other crap asserted. No. Because you know what? Donald Trump has the full authority to waive those privileges. So what I would do, if as the ninth bucket, is I would identify, if I was a gun rights organization, I would be identifying the documents that we would like to get from the Biden years, like all the emails between the Office of Gun Violence Prevention and every email that was sent to some external person. I would ask for every one of those emails. And in this context, I would have the Department of Justice, on behalf of Donald Trump, waive any and all privileges and defenses. There's no executive privilege here. There's no attorney-client privilege here. There is no deliberative process privilege. Nothing, nada. Let those documents go right out the door as soon as they're collected. Don't assert any privileges or any defenses. Get it out the door, because I think the more Americans can see the games that were getting played by Joe Biden and deep state to take away our rights, the better it is. And that would be the ninth thing. I would just make sure that someone is monitoring the FOIA requests for all Second Amendment gun-related issues, including FOIA requests to the ATF, and make sure those responses to the American public do not get held up. Turn those documents over to the groups that do FOIA requests, including the gun rights groups. I don't know if they do them, but if they don't, they should start doing them. And that would be my ninth bucket. All right, folks. So there you go. That's the Mark Smith 9 buckets of things that I would like to see the executive order report to the executive order by the Department of Justice say. I'm sure you'll have other ideas. Let me know if you think I'm off base on anything. And again, thank you again for tuning in. Make sure you follow me on X at For a Box at Diner. Don't forget to subscribe here on YouTube and Rumble. We're trying to get to 200,000 subscribers on YouTube. And again, thank you very much for tuning in here at the Four Boxes Diner.
Orders up. Table 2A.